Hello students, today we will be talking about nature and scope of criminal justice in India. Now, what is the purpose of criminal justice in India? The purpose of the criminal justice system is to deliver justice for all by convicting and punishing the guilty. There are three main components of the criminal justice system: law enforcement, courts and corrections. These three components work together to prevent and punish deviant behavior. Thus, a criminal justice system is a set of legal and social institutions for enforcing the criminal law in accordance with the defined set of procedural rules and limitations. Now, precisely saying, criminal justice system includes the process of defining the crime, the investigative agencies and the procedure to be followed in the administration of criminal justice. Now, what does it mean? It means the procedural criminal laws. In short, we can say that the criminal justice system encapsulates all those components that are needed to deliver justice to a victim of a crime. Now, what are the nature of criminal justice systems? The nature of criminal justice system of India follows the British model. Constitutional guarantees protect the accused, as do various provisions embodied in the 1973 Code. The machinery for prevention and punishment through the criminal court system is based on the Code of Criminal Procedure of 1973. It contains provisions related to investigation, inquiry and trial besides the correctional services. Provisions have also been made for giving legal aid to an indigent accused in cases triable by a court of sessions. The state government may extend this facility to other categories of cases. Now, the court is empowered to order payment of compensation by the accused to the victims of crimes. The accused is entitled to an opportunity to make representation against punishment before it is imposed. The criminal justice system of India is administered in two-folded manner. Now, what are these two folds? Number one, by criminal laws liable for proper criminal justice administration, and number two, by mechanisms or agencies liable for proper criminal justice administration. Now, let me talk about the first one, that is the criminal laws for the administration of criminal justice. Criminal laws of India encapsulates both the substantive criminal law and the procedural criminal law. Now, what is substantive? Substantive criminal law defines crimes and punishments against such acts. The penal code classifies crimes under various categories. Now, what are these categories? They are crime against the state, the armed forces, public order, human body, the property, and crimes relating to elections, religion, marriage, health, safety, decency and morals. Let me first explain you the meaning and concept of crime before explaining you the nature and scope of criminal justice. Now, what is crime? In common parlance, crime is regarded as an act punishable by law. It's very simple. Now, the Blackstone defined crime as an act committed or omitted in violation of a public law, either forbidding or commanding it. Now, there are 4 elements which go to constitute a crime. They are: number 1, human being. The first element requires that the wrongful act must be committed by a human being. You know what used to happen in ancient times is that when criminal law was largely dominated by the idea of retribution, punishments were inflicted on animals also for the injury caused by them. For example, a pig, he was burned for having devoured a child, and a horse was killed for having kicked a man. But now, if an animal causes an injury, we do not hold the animal liable for such injury. The second important essential element of a crime is mens rea, that is Latin for guilty mind. Every crime requires a mental element that is considered as the fundamental principle of criminal liability. All the crimes generally contain mens rea as an essential element. Criminal laws of India have been defined so carefully, expressing the requirement of mens rea. It is represented by the words dishonest intention, maliciously, without the consent, wrongfully, etc. Though this is not an inviolable rule of laws, certain acts by virtue of their nature have been made an offence punishable under law, even if it's done without having guilty mind. Now, let me talk another term which is called actus reus or illegal act or omission. The third essential element of a crime is actus reus, that is Latin for guilty act. In other words, some act or illegal omission must take place in pursuance of the guilty intention. Actus reus is the manifestation of mens rea in the external world. Now, let me talk about injury to another human being. The fourth requirement of a crime is injury to an individual or the society at large. The injury should be illegally caused to any person in body, mind, reputation or property, as according to the section 44 of IPC 1860. The injury denotes any harm of whatever nature which is illegally caused to any person in body, mind, reputation or property. The primary object of criminal procedure is to ensure a fair trial of accused persons. The Criminal Procedure Code 1973 provides the process of administration of criminal justice, that is investigations, inquiry and trial. It creates necessary mechanism for the detection of crime, recording and framing of charges, procedure of arrest of criminals, collection of evidence and determination of guilt or innocence of persons, process of awarding of suitable punishment on the guilty person. In addition, it also deals with prevention of offences, maintenance of wives, children and parents, etc. The well recognized fundamental principle of criminal jurisprudence are presumption of innocence and right to silence of the accused, burden of proof on the prosecution, and the right to fair trial. The criminal jurisprudence has given a wider area to the accused. The burden of proving the guilt of the accused is always on the prosecution. It must prove the case against the accused beyond reasonable doubt. In case of any doubt, the accused would get the benefit of acquittal. Any confession made by the accused before the police officer is not admissible and cannot be made use of during the trial of the case. Now, let me talk about mechanism or agencies for the administration of criminal justice. Now, as we have discussed before, criminal laws are only set or norms that controls and regulates the conduct of people. Some mechanism is also required to deal with the criminal cases in the prescribed manner. It comprises of number 1, the investigating agency. Law enforcement officers investigate crimes and gather and protect evidence. They may arrest offenders, give testimony during the court process and conduct follow-up investigation if needed. Number 2 are the prosecutors. Prosecutors are lawyers who represent the state or federal government, not the victim, throughout the court process from the first appearance of the accused in court until the accused is acquitted or sentenced. The prosecution is conducted by the public prosecutor or additional public prosecutor or special public prosecutor or assistant public prosecutor appointed under the Code of Criminal Procedure. As per the provisions of section 301 clause 2 of the code, a private person can also appoint a private counsel to prosecute any person, but such a private counsel or pleader shall act under the directions of the public prosecutor or assistant public prosecutor and may, with the permission of the court, submit written arguments after the evidence is closed in the case. Prosecutors review the evidence brought to them by law enforcement to decide whether to file charges or drop the case. Prosecutors present evidence in court, question the witnesses and decide at any point after charges have been filed whether to negotiate plea bargain with the defendants. They have great discretion, or let us say freedom, to make choices about how to prosecute the case. Victims may contact the prosecutor's office to find out which prosecutor is in charge of their case, to inform the prosecutor if the defense attorney has contacted the victim and to seek other information about the case. Then we have defense attorneys. Now, what is a defense attorney? A defense attorney is a lawyer representing the defendant in a criminal trial. Most defense lawyers specialize in criminal defense and some further narrow their practice to specific types of criminal defense. However, no specific degree apart from law degree is required to be a defense lawyer. defense attorneys defend the accused against the government's case. They are either hired by the defendant, or for the defendant who cannot afford an attorney, they are assigned by the court. While the prosecutor represents the state, the defense attorney represents the defendant. Then we have something called criminal courts. Courts are run by judges, whose role is to make sure the law is followed and oversee what happens in the court. They decide whether to release offenders before the trial. At the apex is the Supreme Court, which has original, appellate and advisory jurisdiction. Below it are high courts that preside over the states and union territories. Now, besides the high court and the courts constituted under any law other than this code, there shall be in every state the following classes of criminal courts, which are Court of Sessions, judicial magistrates of the first class, and in any metropolitan area, metropolitan magistrate. The high courts have supervisory authority over all subordinate courts within their jurisdiction. In general, these include several district courts headed by district magistrates, who in turn have several subordinate magistrates under their supervision. The Code of Criminal Procedure established 3 sets of magistrates for the subordinate criminal courts. Now, let me talk about correctional services. Correction officers supervise the reformation and rehabilitation of convicted offenders when they are in prison or in the community, on probation or parole. In some cases, correction officers prepare pre-sentencing reports with extensive background information about the offender to help judges decide sentences. The job of correction officers is to make sure the facilities that hold offenders are secure and safe. They oversee day-to-day custody of inmates. Next comes victim rehabilitation. The Code of Criminal Procedure 1973 has recognized the principle of victim compensation. Section 250 authorizes magistrates to direct complainants or informants to pay compensation to people accused by them without reasonable cause. Again, Section 358 empowers the court to order a person to pay compensation to another person for causing a police officer to arrest such other person wrongfully. And finally, Section 357 enables the court imposing a sentence in a criminal proceeding to grant compensation to the victim and order the payment of costs of the prosecution. However, this is on the discretion of the sentencing court and is to be paid out of the fine recovered. Now, let me conclude by saying this, that protection of life and liberty have been given a preeminent position in our Constitution by enacting Article 21 as a fundamental right and imposing a duty on the state to protect life and personal liberty of every citizen. Any deprivation or breach of this valuable right is not permissible unless the procedure prescribed by law for that purpose is just, fair and reasonable. The penal philosophy embraces the ideals of preventing crime and rehabilitating criminals. Country suffers from low judge population ratio, because of which dependency of work increases. Therefore, the judges take a long time in delivering judgments. Litigation is a time-consuming and lengthy procedure, the two areas which need special attention for improving the quality of justice. With that, we end today's class. Thank you very much.